On Oregon's 1857 Constitution, one clause said that a black person who was not already in the state could not come, reside, own real estate, make contracts, or bring a suit in court. Oregon entered the Union as a free state. But free did not mean a black family was free to move there. That contradiction is not hidden in a mood or a rumor. It is in the document, and one family changed its route because of the distinction. In 1844, George Washington Bush crossed west with his wife Isabella, their 6 sons, and a wagon party that expected to settle in the Willamette Valley. Bush was a successful farmer from Missouri, not a symbol waiting for a history book to use him. He had land experience, a family, a destination, and a problem created by Oregon's new exclusion law. The law barred slavery, but it also ordered free black residents to leave after a deadline that depended on sex. For a black man over 18, the deadline was 2 years. For a black woman, it was 3. The law originally threatened lashing for anyone who remained. That penalty was later softened, and the whole law was rescinded in 1845 before anyone could be punished under it. But the threat had already told Bush what Oregon's lawmakers wanted the territory to become. When his party reached the lower Columbia, Bush did not settle in the Willamette Valley. He went north, beyond the reach of the Oregon law, and settled near Puget Sound. There, he built a farm, a grist mill, and a sawmill in what became Tumwater, Washington. The Oregon law did not erase Bush's ability to build. It changed where that building could happen. That is the first fact this story needs to hold. An exclusion law does not have to remove every person in order to change a map. It can change a route before the wagon reaches the destination. Oregon's early lawmakers were not deciding any one black family's full future. They were narrowing the choices available to black migrants who were considering Oregon at all. The record shows a territory trying to be free of slavery while also trying to be free of black residents. Those were not the same project. They were 2 choices made in the same place. The first exclusion law did not last. The idea behind it did. In 1849, Oregon's territorial legislature passed another exclusion law aimed at black newcomers entering or residing in the territory. This time, the record includes enforcement. Jacob Vanderpool, a sailor reportedly from the West Indies, was arrested and expelled in 1850. Exclusion orders were also issued against at least 3 other black people, although support from white residents allowed them to stay. That matters because law and enforcement did not move in a straight line. The rules were real. Their application was uneven. Black presence was never erased from Oregon's history, and black people who did arrive made homes, businesses, churches, and organizations. But the legal message was unmistakable to anyone considering the journey. Oregon was not simply leaving black migrants to decide whether the frontier suited them. Its lawmakers were telling them that residence itself could be contested. The largest version of that decision arrived when Oregon prepared to become a state. Residence was only one part of the choice set. Land was another. In 1850, Congress passed the Oregon Donation Land Act, the law that turned large portions of the territory into private claims for settlers who met its conditions. Its eligibility language granted land to every white settler, while expressly including American half-breed Indians. The phrase was a federal rule, not Oregon's constitutional clause. Its effect was just as practical. It restricted who could turn years of work on a claim into legal ownership. For incoming white men, a standard grant could reach 320 acres, with an additional 320 acres available through a wife's claim. For black settlers, the statute closed that path to title. That distinction helps explain why the story cannot be reduced to a single Oregon clause. Black migrants confronted a series of different rules: a territorial exclusion law about residence, a federal land law about ownership, and later, a state constitution that joined residence, property, contracts, and courts in one restriction. None of those instruments covered every situation in exactly the same way. Together, they changed what moving west could mean. For Bush, the question was not whether he could farm. He could. The question was where he could do it, and whether the legal structure around the land would recognize the work. That is why his route deserves more attention than a historical footnote. The map was not simply expanding westward for everyone who could reach it. Government was deciding whose settlement it would recognize, protect, and turn into property. The record also keeps us from making the opposite mistake. The region was not an empty landscape waiting for white settlers. Black workers, families, sailors, farmers, and entrepreneurs were present in the region, even as law and custom made residence and ownership less secure. The point is not to turn every black migrant into proof of freedom. The point is to see how much work was required to build a life when the law treated that life as conditional. In 1857, Oregon Territory put 3 linked questions before an electorate limited to white men. The voters considered a constitution, slavery, and the exclusion of African Americans. They approved the Constitution by 7,195 votes to 3,195. They rejected slavery by 7,727 votes to 2,645. And they approved exclusion by 8,640 votes to 1,081. That third tally is the hard evidence moment. Oregon did not become a free state and accidentally carry an exclusion clause into its founding document. Voters approved the 2 positions separately. The Constitution prohibited slavery, while Article 1, Section 35, prohibited black newcomers from being in the state, owning property, making contracts, or maintaining a suit. Residence, property, contract, and court access are not ceremonial rights. They shape whether a family can settle, whether a business can hold an asset, whether an agreement can be enforced, and whether a person has a legal forum when another person breaks one. Congress admitted Oregon to the Union in February 1859 with that constitutional settlement in place. It was the only free state admitted to the Union with a racial exclusion clause in its constitution. The clause did not apply retroactively to black residents who were already legally in Oregon, and it was never enforced. Several attempts to create an enforcement law failed in the legislature, including a proposal that would have empowered county sheriffs to deport black residents after a county-by-county census. The 14th Amendment later rendered the clause moot, yet Oregon voters did not formally repeal it until 1926. That sequence is not a loophole in the story. It is the story's limit. The Constitution tells us what voters approved and what the state placed in its Bill of Rights. It does not license a claim that every black Oregonian was removed, or that the clause enforced itself for decades. Its power was partly deterrence. It announced what kind of place Oregon intended to be for a black person, deciding whether to come west, own land, sign a contract, or ask a court for protection. That message outlasted the first statutes. But the state archive is not the only archive. By the early 20th century, black Portlanders owned hotels, restaurants, and small businesses, while fraternal organizations and churches built community life beyond the lines of a constitutional clause. The weekly newspaper that most clearly preserves that work was the Advocate. Beatrice Morrow Cannady edited the paper and later owned it. In 1922, she became the first African-American woman to graduate from Northwestern College of Law in Portland, 2 years after joining the Advocate. She became a founding member of the Portland NAP. Through the paper, Cannady confronted discrimination in restaurants, hotels, and movie theaters, and she challenged the exclusion of African-American children from public schools in Oregon and Washington. The Constitution records the state defining who could belong. Cannady's paper records people refusing to let that definition stand alone. That is why she matters here. Not as a rescue figure. As evidence that Black Oregonians were producing their own record of the fights, institutions, and choices that official documents leave thin. The next set of instruments did not repeat Article 1, Section 35, word for word. They worked through property, lending, and public housing. In Portland, exclusion later moved through a different set of papers. Property deeds carried restrictive covenants that barred black buyers, along with several other racialized groups, from occupying or purchasing homes in named neighborhoods. In 1919, the Portland Real Estate Board's Code of Ethics barred realtors from selling property in white neighborhoods to people of an excluded race. Federal home security grading then treated the presence or absence of racial restrictions as part of how neighborhoods were evaluated for loans. These were not Article 1, Section 35, continuing unchanged. They were later instruments, with different actors and a more local mechanism. Private owners wrote covenants. Real estate institutions enforced professional rules. Public authorities shaped which neighborhoods received credit and which received investment. The effect was a narrower housing map for Black Portlanders. Between 1910 and 1940, the real estate industry, local government, and private landlords concentrated more than half of Portland's Black population of 1,900 people in Albina. Then wartime labor changed the scale of the question. Beginning in 1942, Black workers moved to Portland for jobs at Kaiser shipyards. The Oregon Encyclopedia counts 23,000 Black workers in that migration. The work was wanted. Equal access to the city was not. The Housing Authority of Portland restricted Black workers to developments at Vanport and Guilds Lake. Vanport was not a temporary backdrop with a few barracks and a sad ending. At the end of the war, it was Oregon's second-largest city, with shopping centers, a hospital, schools, daycare, recreation, tenant councils, and a population that reached roughly 42,000. It was a working city, with Black residents building ordinary life inside extraordinary constraints. The Housing Authority described its racial lines as the result of free choice among available apartments. Historical research records tenants being steered to different sections on the basis of race. The label said choice. The allocation narrowed it. That gap between official language and administrative practice is what a document-led history can show. Vanport's Black residents attended integrated schools, but they encountered segregated medical facilities. The sheriff's office also tried to enforce informal segregation in recreational spaces. And in 1945, Housing Authority, city, and state officials met to discuss housing restricted to Black occupancy. Vanport was not total exclusion. It was not equal inclusion either. It was a city where labor, housing, medical care, and recreation were administered in pieces. That phrase matters because it describes more than one law. Different institutions narrowed different choices at different times. Then Vanport was destroyed. On May 30, 1948, floodwater breached the Northern Pacific Railway embankment, and residents had roughly 35 minutes to escape. 15 people died. More than 5,300 families were displaced, about one-fifth of them African American. The flood produced enduring rumors that officials withheld warning or concealed a higher death toll. The record supports the flood, the displacement, and the housing emergency that followed. It does not establish those rumors as fact. The documentary question is therefore not whether a hidden plot caused the flood. It is what Black families could do after a city of homes disappeared, when the rest of Portland's housing market was already restricted. Vanport's scale makes the next point harder to ignore. This was not a marginal camp that could be dismissed as an exception. It had schools, childcare, a hospital, stores, a movie theater, recreation, and a city government created around a wartime housing project. Tenant councils gave residents a way to organize, even though the housing authority limited them to an advisory role. The community included activists who organized among tenants and residents who made a city out of a place built quickly on a floodplain. That ordinary infrastructure matters as much as the restriction. Without it, Black residents appear only as workers assigned to a housing project, and later, as families displaced by a disaster. The record is fuller than that. Vanport held work, childcare, school, neighborhood politics, and community argument at the same time that its racial lines narrowed access. Its contradiction was not a side note. It was the daily form of administered choices. After the flood, displaced Black families entered a Portland housing market that had already been shaped by covenants, lending practices, and public allocation. Albina became the place where those pressures converged. By 1960, 4 out of 5 Black Portlanders lived in 4.3 square miles of the neighborhood. That concentration did not come from one clause written in 1857. It came through later choices about who could buy, where workers could live, what housing survived, and which neighborhoods received public investment. Albina was also a place of Black institutions. Churches, businesses, jazz clubs, schools, organizers, and families made it a center of Black Oregon. Vancouver Avenue First Baptist Church grew after the flood as displaced families moved into North and Northeast Portland. The church did not make the housing restrictions disappear. It created support, fellowship, and services inside the city that those restrictions had helped shape. That is not an uplift ending. It is a record of people building institutions where the public map had made ordinary security harder. The city then made more decisions that altered the neighborhood. In 1956, Portland voters approved Memorial Coliseum in the Elliott neighborhood, destroying commercial establishments and 476 homes, including homes owned or occupied by Black residents. At about the same time, the Oregon State Highway Department cleared stretches of Albina for Interstate 5. Those projects had names, votes, agencies, maps, budgets, and addresses. They did not happen because a neighborhood simply changed. They happened because institutions made choices about land, roads, and redevelopment, and the consequences reached businesses, homes, streets, and the continuity of a community. That is the payoff of Oregon's record. The 1857 exclusion clause does not explain Oregon forever. It does show that Oregon's Free State story was never enough to establish Black belonging. The clause, the land rules, the covenants, the housing assignments, and the renewal projects were not one continuous law. They were separate instruments, but they shared a practical question. Who could enter, stay, own, contract, live, and remain when the map changed? Black Oregonians answered that question with migration, businesses, the advocate, churches, tenant organizing, legal challenges, and neighborhood life. The record is not a story of Black absence. It is a story of Black presence, made more difficult, then made visible through the institutions people built and the documents they left behind. If you want the next document in this story, follow Portland's restrictive covenants and housing maps block by block, because that is where the broad promise of a free state became a set of local decisions. Read the clause, then read the map.